Good evening, everybody, and welcome to another Portugalist webinar, where once again we are joined by Sandra Gomes Pinto. And this particular webinar, we're going to be talking about wills, inheritance, and estate planning. It's not as a joyful topic, let's say, as some of the other ones that we've done, but it's a very important topic nonetheless. And I think it's something that, regardless of whether you're moving to another country or you're staying put, it's something that we don't think about and don't like to think about, but it's something that's very, very important to think about. I've had a lot of questions from people, some of them quite specific and quite complex, and Sandra is going to take us through all of them today. There's quite a few there. I know in the past we've covered some things in a lot of depth, and people are always impressed with how much knowledge you bring to these webinar. So Sandra, you will be a very, very familiar face to everybody here. But just for those that don't know, maybe you could give a little bit of background to what it is that you do, and maybe perhaps in relation to sort of wills and inheritance planning.
So, okay. It's also always a great pleasure to be here with you, James.
Thank you.
We do share the same values, and I repeat that again and again. With age, we become a little bit repetitive in respect to some things, but I think it's important to reiterate that we share the same values of transparency, directness, honesty, and this is, for me, it's quite important. I'm a lawyer in Portugal for 30 years. I'm still very passionate about what I do, about law, about knowledge, about assisting people, about providing the best solutions designed specially for each person. I believe, in respect to this topic, I believe a lot in advocacy, and I was always a litigator. And I understand that, especially with the present conditions in Portugal, with litigations, most times everybody loses. And these successions, one of the first important cases I had to deal with was the successions of my grandparents, which I tried to get a lawyer to take care of this. And I managed to, but then again, I couldn't, so I had to take care of this. And I understood that, especially in inheritance, when people litigate, or whenever there's argument, many times, as in many other cases in litigation, it's not the assets that it's at stake. Sometimes it's much more the family relations, it's complications. So I think in this area it's especially important to plan, to prevent problems, to try to solve the family problems prior to any other event. So in this, I think a preventative an advocacy that avoids conflict. This is something I believe for a long, long time, especially having the experience that it's possible to litigate 20 years for an inheritance in Portugal without it. It doesn't have to be especially complicated. I went to Albufeira recently to a case that most of the important stuff was solved. But I started working on this case, and I solved that there was just a little thing that we still have to end. But I started working, and it was extremely beneficial, the solution for my clients. But I started working on this in 1995.
Wow.
So it's really, and the judge really didn't know how to solve it. And I think I will have to try to guide her through the process and tell that some things that the previous judges did during pandemic are void, and so it will have to be repeated. So in this team, I think it's really important to have to plan and to prevent problems. In respect to myself, as I initially was saying, I'm a lawyer here for 30 years. I always worked with foreign clients, even when that was not in the norm in Portugal. I worked for some important projects, such as the enlargement of the bridge 25 de Abril as a lawyer. as a young lawyer, and also the modernization of the German school, which is a project that was partially subsidized by the German government, and it's a relevant project in Portugal for architectural purposes. I also lecture in Heidelberg, which is one of the top universities in Europe, in the world. And I often do presentations and lectures all over the world about immigration, investment in Portugal, litigation and arbitration. I think
Okay.
this is enough about me. What defines at these last years in my firm, we are focusing a lot helping people that relocated to Portugal from a legal point of view. We also have a relocation team in place, and we like to partner with people and to help them in this journey so they have a smoother journey.
Well, thank you very much for that, Sandra. That is obviously quite the CV. Um, Now we're going to jump into the questions, and I guess I'll just start with a simple one, which is it worth it to make a will?
Um, I would say normally yes,
Okay.
but it depends. If you don't have assets, or if you don't have any registered assets, if you don't own a home, a land, or a car, it might not be worth doing it. It depends. You have to at least have a home. I believe once you have a home or once you have land, it might be worth doing it. Yes.
Okay.
Especially if it is a situation where you have connection with one or more jurisdictions. Because if you're English or if you are American, immediately there is questions in respect to the applicable law.
Okay.
And there can be the possibility to choose the applicable law and to choose how things will be done. And you can only do it, this cannot be done after someone dies. This can only be done in a previous moment before your death. So by the time you can draft a will.
Okay. Let's suppose I have a house in Portugal, but I don't have a will. Um, and I am left by I leave a wife and two children behind. What happens in an instance like that?
If you have a wife and two children,
Mm-hmm.
probably there will be the intervention to divide the assets. You'll have to, your wife, after you die, would have to declare your death.
Okay.
There will be a escritura de litigação de herdeiros, which is a deed where your wife, as administrator of the inheritance, will declare who are the heirs.
Okay.
And after that, there will be escritura de partilha. It's a deed where the assets are divided. But when our children involved, there should be an intervention of the public attorney. This is
Okay.
something that cannot be done privately without supervision of in approval of the public authorities in Portugal, because their rights have to be protected.
Okay, so it sounds like if I make if I don't have a will and I have assets in Portugal, then Portuguese law will apply. Um, is that correct?
Yes, I would assume so, but I didn't. That might not be the case.
Okay, interesting.
It depends if you're European or a non-European person. This is the case if you're European, there is EU regulation, and by default, the applicable law is the law of the place of residency. But you can apply, there is a possibility to choose another law if you have connections with one or more jurisdictions, if you are an European.
Okay.
If you are a non-European, I would say that the law by default is the law of the country of nationality, but you still have the possibility to apply the law of the country of your residency by the time you die. So there is always a possibility of choice, of regulating, that you should not, you should take advantage of this possibility, because this might have an important impact also from a financial point of view. And what can be done? As you know, Portugal has mandatory heirs. You just cannot, you cannot freely dispose on your assets if you have a wife and children.
I see. I was reading a case the other day. I think it was in the UK, and someone decided they didn't want to give anything to their family because they had had enough of them. That wouldn't be possible in Portugal then.
In a normal case, no.
Okay,
Only if the Portuguese law, that would be possible in Portugal if you chose in the will not to apply the Portuguese law.
I see. Okay,
With the application of it is possible that in Portugal, you don't apply the Portuguese law if you have connections with other jurisdictions that are, and this is allowed by the law. It is possible not to
okay,
apply the Portuguese law here.
I see.
But if with the Portuguese law, you could only waive your children and your wife if they had been condemned for terrible crimes against you or something like that.
I see.
In not only in extreme situations, you can eliminate them from the inheritance.
Okay. So it sounds like if you don't have a will, and especially if you're a foreigner living in Portugal at the time, it can get a little bit complicated, but having a will allows you to sort of set the terms of how everything will be arranged. Is that
Yes,
correct?
yes,
Okay.
yes. And even if you have a wife here and you are a foreigner, it's very
Mm-hmm.
important to make sure that the marriage is transcribed and
Okay.
can be valid and enforceable in Portugal, because this will be very, very important for the inheritance. And I heard of a case, it was not our case, of one foreigner that had problems because they didn't transcribe the marriage into Portuguese law, and it was not enforceable here. So the wife had difficulties because she wanted to send the body back to their home country, and she faced severe difficulties because the marriage was not enforceable and valid here in Portugal. So there are
Okay.
all these details have to be attended to prevent, and the better prepared you are, as always in life, the better.
And transcribing a marriage into Portuguese law, is that a fairly simple thing?
Yes, it is fairly simple, but I would not advise you to go to the civil registry to do so, because it would
Okay.
be a nightmare for a private person to do so
Okay.
if you're not proficient in Portuguese, and if you don't love complicated bureaucracy. Yes. And
I
lots
don't
of
think I've
people
met many
queuing.
people who love
Yes.
complicated bureaucracies.
No, there are some. Actually, there are some that do study things a lot in the internet and manage to navigate the bureaucracy quite well.
Okay. So would this be a something that your firm could offer people?
Yes,
Okay,
yes, this we
fantastic.
could help people with. But as always, if you prepare ahead of time, if you have things prepared, as you know, as the Portuguese, we are not very used to prepare things. We are used to work hard, to be flexible, to create solutions, but not to prepare things. And but I think, and I am always saying this to my children, you have to prepare properly to improvise. So it's
Yeah.
better that it's some, especially these legal matters, that you prepare well and avoid conflicts and avoid additional problems and uncertainty, and that your loved ones will have to navigate the bureaucracy of a country they don't know, in a language they're not proficient with, in a place where typically they would not have someone they trust.
Okay. Now, are there different type of wills in Portugal?
Yes, yes,
Okay.
there are different types of wills. There is the testamento public, the public will, and the testamento cerrado, if you do a literal translation, the sealed testament, I would always do a will with a notary in their books, written by them. I think this is the way to go, to be 100% sure that you won't have void clauses and something. You know exactly what you're doing. So I think a public will is always the best solution, but it's important to know, to take into account that the name public can be a little bit not completely accurate, because these wills are completely secret.
Okay.
And the notaries, whenever you go to clients, they even ask the clients if they want the lawyer to remain there, because they know how important in these situations is for the person to keep the content of the wills private. And this is something they instigate persons to do, because in their experience, they've seen that's not a good thing to tell your possible heirs or your children or your spouse what is the content of a will. So the content of the will be completely secret, but it's possible when you have your parent or someone from your family died in Portugal, you can ask the land registry, the central registry, whether that person did draft a will in Portugal. And they should be able to do it and where it was done. So it is possible to assess through a central registry, and to know if a person did a will, but the content of the will, it is totally secret and should remain so. It is important. We understand now, having dealt with many families, with many situations, that whenever a person drafts a will and has a will, its content should remain private and secret. And the fact that the will, there is this name, public will, doesn't mean it's not, its content, it's not private. It's the other way around.
That's good to know. Okay, it's the other way around. And I noticed there was a question, just because we were talking about sort of registering a marriage and the help that that can have. What about people who are in a long-term relationship, living together, but not legally married?
Oh, for those who are not legally married, not in respect directly to inheritance, because the Portuguese legislator has a notion, which I think it's important, that's the following. The fact that people didn't enter into a marriage contract means that they don't want the full effects of a marriage contract. And you should not apply the full content and the full effects of a marriage contract for people who didn't want to enter into this. But I think for those who live together and are not married for over 2 years, in other situations other than inheritance, they are treated as married couples and have many benefits. I would advise them, after 2 years of living together, to register their union of facto before the parish, the Junta de Freguesia, because that will, from a perspective of proof, that would make things much easier. I just had a foreign that works in my home, and she lived together with a boyfriend for 14 years, and he had a problem, a severe disease, and then they didn't want to get married, but for her to get his pension, it was really a nightmare. It was really tough. Before the social security, you don't understand what kind of proof we had to do, and it would have been much easier if they had registered the union fact before the Junta de Freguesia.
Okay.
And that is especially important when people live together, because then the not the spouse, but the wife, the woman that lives together with a man, would have the right to stay in the house for in their family house for a while. So that would be important for her rights.
Okay.
And also for her to be entitled to a pension in terms of proof, it would simplify things a lot.
So I guess what we're talking about today is simplifying everything for
Yes,
people
yes.
who are left behind, and to make things
Oh,
easier
so
for.
I think this is not it's good to repeat for
Mhm.
those that live together. Please register
Okay.
before the parish, the Junta de Freguesia, their non-marital partnership, because that can be really important after their loved one deceives. So if the person to be entitled to a pension, which can be extremely, from a financial point of view, very important. And if you have the proof, the right proofs, things will be much less complicated.
Okay, I think that's very good advice, and probably not something a lot of people would have thought to do.
Yes, yes, because death is perhaps the only really certain thing we have in our life, but we all live as if we were eternal.
Yes.
This is
Death and taxes, I think.
yes.
So could you explain the split? Let's say that someone passed away and they
Mhm,
had a wife and children, and
mhm.
I think you were sort of saying the Portuguese law said it has to go to both. How does this work in terms of a split?
That it will depend on the number of children,
Okay.
because the wife is always a little bit protected. But if she has a wife and two children, and if there is no will, you can divide equally among the three of them.
Okay.
If you draft a will, you have the possibility to dispose of 1/3. The other 2/3 of your inheritance will mandatory have to according to Portuguese law, have to be divided among your wife and your children.
Um, so could you explain that again? Sorry, I missed that.
Okay, so you have a wife and two
Yep.
children.
Mm-hmm.
Uh, you don't have a will.
Okay. No.
The division, your inheritance will be divided in 3 equal parts.
Okay.
You have a wife and two children. You decided to have a will.
Mm-hmm.
In the will, you can dispose freely of 1/3. The other
Okay.
2/3 have to be divided equally among your wife and your children. But you can dispose of 1/3 and say that this 1/3 will go to your children or to your wife or to someone else. It is even possible that you dispose who shall take care of your children, although this will not be automatically applied. This might be challenged, but this is something you can write in a will.
Okay. Okay, very interesting. So that
Yes,
if I had a will, that 1/3, I know some people have asked about donating to charity. Could
yes.
1/3 of that could freely go to a charity if in the case of not having a will, is that correct?
No, in the
Okay.
case you for you to donate something to a charity
Mm-hmm.
after your death as an inheritance, it's mandatory that you draft a will. Because
Okay.
if you don't have a will,
Mm-hmm.
the inheritance will go to your mandatory heirs.
I see.
And the
Okay.
first category is your wife and your children.
And if I do have a will,
Mhm.
and under Portuguese law, am I able to give the entire amount to charity or just 1/3?
I just mentioned that.
Okay, just 1/3.
So we have forced heirship in Portugal. So in a standard situation, you can only dispose of 1/3 of
Okay,
your assets. in terms of inheritance. The other 2/3 will go in a normal situation. It is mandatory that they will go to your forced heirs, which the first category is your wife and your children.
Okay.
Was it clear enough?
That's very clear for me now. I understand. So I did see that question pop up about the charity, so we can answer that well. If someone did want to donate their proceeds to charity, let's assume they did or didn't have family behind, what would be the best way of doing this?
Mhm. It depends. You can do that before your death, and then
Okay,
you can dispose freely of your assets unless you are donating something to your mandatory heirs. In that
I
case,
see.
that it's different. The regime is different. So you can do before your death. If you want to do it in a will, in normal terms, you can only dispose of 1/3 of your assets. In certain cases, you can dispose of half if you just have a wife, for
Okay.
instance, and if you don't have mandatory heirs, then you can dispose of all your assets.
Okay. That is okay, that is good to know. And we're talking about wills with relation to wife and children, but for those who are in same-sex marriages, this is treated the same as a
Yes,
man and
same,
woman.
same. We were one of the first countries in the world to accept first same-sex marriages. So it is treated as a normal wife, as a normal,
Is-
exactly as a marriage. There
Okay.
is no distinction in the Portuguese law whether it is a gay marriage or not.
Okay, that is really good to know, but I thought I would just clarify that for anyone. What are the procedures then for drawing up a will in Portugal?
So there's two options. You can go to a notary yourself
Okay.
if you wish to do so. I think after of so many years of practice that it's really important, if you have a trusted lawyer, that can be precious. And if you have someone that gives you advice and that you can even nominate as an executor of the will, and that may help you, your loved ones, to navigate the bureaucracies after you're deceased. I think this can be impactful, but you can do it with a lawyer or without a lawyer. But I would always advise you to do in the books of a notary.
Okay. So what does that mean in the books of the notary specifically?
It is specifically, there is two types of wills, testamentos cerrados, which you can draft and then would have to be approved by the notary. And there is these public wills, which will be immediately incorporated in the books of the notary. And I think this is the best solution.
Okay. So next question, is there a vital testament in Portugal?
Yes, there is.
Okay.
And for those who are not familiar with the expression, is a testament for those when you are no longer in possession of your capacity to have to make conscious decisions. You
Mm-hmm.
may appoint a third person to make the decisions on your behalf,
Okay.
or you may give some guidelines, some directives on what to do, if there should be, if you want to donate your organs or not, if you want transfusions, some religions people don't want, if you want some kind of invasive treatment or not. So you can give the directives and you can appoint a third person to take these decisions on your behalf. It's important to note that this is only valid for 5 years. And that in Portugal, by default, many, if you don't say anything, in many cases, the public authorities have the possibility to use your organs for other persons.
Okay. And
You know,
so
which
this,
I think it's a good thing.
mhm. So if I'm draw up a vital will,
Mm,
and then I continue to sort of decline in mental health over 5 years.
mm,
After that 5 years, what if I'm not in a stage
mm.
to think about nominating someone else at that point of view?
If you're not in the situation, your family members can
Hmm.
start a procedure
Okay.
that you are declared by the court incapable of taking your decisions, and then someone can take decisions on your behalf.
Okay.
This have to be the way because they want really a judicial procedure. So they legally you would be considered incapable of taking your own decisions. This is a serious procedure.
Hmm.
So the Portuguese authorities want to make sure that this is really the case, because otherwise it could be a procedure used by less well-intentioned people.
Sure. And if someone did not want their organs donated, is that something they could state in their will?
Yes.
Okay.
Not in their vital will, not
Not
in
in,
a normal will before the notary.
okay. Okay, good to know. Now let's talk about inheritance tax, because that one has come up quite a bit. Is there inheritance tax in Portugal?
There isn't for direct heirs and spouses.
Okay.
For the other heirs, there is
Okay,
a stamp
so
duty.
for children.
Yes.
And this stamp duty, roughly, so
Mm,
there isn't inheritance tax, but there is stamp duty.
yes. There,
Um,
there is also stamp duty for the registry, but it's something irrelevant.
okay,
For if you're not talking about direct heirs, for direct heirs and spouses, for your children and your spouse, then they don't have to pay inheritance tax, but they will have to pay a stamp duty by the time they register. But it's something less than 1%. It's irrelevant. If you're talking about not your direct heirs, you have to pay 10%
okay.
stamp.
Is there a
But
limit?
this is extremely beneficial. If you
Hmm.
some years ago, I talked in a conference with a very well-known French tax lawyer, international tax lawyer, and he was telling me that in France, many middle-class families could not afford paying the inheritance tax if there was a house in place. So they would have to, normally they have to sell the house in order to pay the taxes. So this is extremely beneficial.
Okay, yes, that's a very good point. So, is there a limit to the size of an estate that can be passed down? Let's say I make millions and millions of euros. Does the inheritance tax rule still apply?
I would say yes, but I will have to check.
Okay.
Normally we dealt with more simple cases in the
Uh,
office. Only
Yes, I have not made those millions of euros yet.
yes,
So,
but there are interesting and very useful solutions in terms
okay.
of creating companies for
Hmm.
those persons. And the truth is, and the we had other cases where I took part as a team member of a big company, and the really rich, they all pay no taxes in respect to inheritance because they plan ahead and do it
Okay.
very well with usage of companies.
So, okay, so definitely plan ahead then.
Mhm.
And how would you know if a deceased person has a will in Portugal? I think you mentioned there's a registry. Um,
Yes, yes, there is a central registry that where you can access this information.
um,
Sorry.
a similar question then would be related to accessing people's bank accounts. I know this can often be a challenge when someone passes away. that you need access to the bank accounts for various reasons, and you can't get into them because you might not have the passwords. The person might not have thought to leave this information behind. Is there a way to do this in Portugal?
So to know if someone has a bank account in Portugal, it is you can the Bank of Portugal has this information and should give this information to an heir, an official heir. If you want to prevent that situation, it's possible to insert one of your heirs that you trust as a co-owner, co-title of the bank account, or as a representative with a power of attorney to use and to use this bank account, and that can prevent some problems.
Now let's see.
And normally there is, if someone is a co-owner of a bank account, there is an assumption, unless it is stated otherwise, that the ownership of the money is half-half.
Okay, that's interesting. So if you are there issues then if you make with regards to inheritance tax, if you make another person half and half the owner of the bank account?
Yes, because just imagine if you have one of your children in your bank account, although this can be challenged, the bank and the authorities in a first analysis will assume that the ownership is 50-50.
Okay, so that's that could
so
complicate things.
only the other half will be inherited.
Can I draw up a Portuguese will remotely, or do I need to be in Portugal?
You need to be in Portugal.
Okay. Now, we have some people who are aware that they will inherit properties in Portugal. Are there any obstacles they face, or perhaps we could reframe that? Are there ways of avoiding these obstacles?
Yes, I think when you know that this is the case, if you have your parent to do a will prior, I think it will simplify things. And to appoint an executor of the will and someone he trusts, that will help the heirs to navigate the Portuguese bureaucracy and the deeds and the taxes and the declarations before the tax authority. And another very important aspect is an heir in Portugal to inherit, to needs to have a tax number.
Okay.
This is not super complicated, but it's better if you can have ahead a tax number. It's less one complication that you'll face. That you know, and also if all the papers in respect to the houses are in order and everything legal, this is also important, because you know we still have these cases of those who have the swimming pool that it's not completely legalized. So if you have having everything in order, the papers in order, the heirs with a tax number, someone that is nominated that you trust as an executor of the will, that will take care of everything, that will inform your heirs. I think this could make things much easier.
Okay. And let's suppose that you realize that you are inheriting somewhere in Portugal. What would be the steps that you would need to take? Suppose you didn't already have the NIF and you didn't have everything in order.
So you'd have to have, the heirs need to have a NIF. You need to have a death certificate. You need to declare, there is a figure in Portugal, it's the cabeça de casal, is the administrator of the inheritance, and this person who should declare in a deed who the heirs are. It's the escritura de habilitação de herdeiros. Then, so then you pay the stamp duty that you have to pay. And then it's important that people agree into the division of the assets, and then they will draft a escritura de partilha,
Mm-hmm.
and then the heirs can register the assets in their name. This said like that can be looks very easy,
Okay.
but then there might be questions in respect the applicable law, interpretation of documents. If you have a foreign will in respect to Portuguese assets, how this will would be interpreted, how this will be enforceable here. It looks very simple,
Mm-hmm.
but you can make it simple, but it can be very complicated.
Sure. I can imagine it's very, it's one thing for people who are living in Portugal to think about this, but a lot of people have family living in other countries. And if they start to inherit something in Portugal in another language, possibly in another side of the world, it probably comes across as very, very complicated to them.
Yes, yes. And there could be also the question of the applicable law, if this is not 100% clear.
Okay.
And if there is a foreign will, how this will be interpreted. All these aspects are quite important. And whether this will and these rules and the way of division would be enforceable in Portugal and would be accepted by the Portuguese authorities.
Okay.
So I think it's planning ahead,
Mm-hmm.
especially when there are cross borders inheritance that involve one or more jurisdiction. Planning ahead and prepare properly and have someone prepared to address the issues that your heirs will be facing can make things much easier. And can also, because also from a tax perspective, it's possible to plan properly to have a much more tax efficient solution for your heirs. So it's really, really important to plan. And in these cross borders inheritance, definitely, because if not, there can be very, very complicated problems.
Okay. Now, a lot of people who've written in have already got a will drawn up in another country. They're wondering, do I need to get a Portuguese will for my Portuguese assets, or could I just update my foreign will? Is there a sort of a best practices here?
My advice, and taking into account my extensive experience in the field with foreign clients, I think if you have assets in Portugal, if you have a home, if you have land, it's better to have also a Portuguese will for the Portuguese assets,
Okay.
where you clarify very well which law is applicable and how
Mm-hmm.
you do it. So I think it's important to have a Portuguese will. But if you have any other will, you should make sure there is no contradiction between the two wills, and that the Portuguese will clarifies very well its content and its effect. Because in Portugal, there is, in the Portuguese law, there is, and also internationally, there is normally the assumption that if you draft a second will, the second might revoke the previous ones.
Okay.
So it's very important that everything is very clear.
Okay. So you need to state something in it along the lines of this is just
Yes,
covers
yes,
Portugal. It does not revoke the other one.
yes.
Okay. And for those that decide to just have a foreign will with their Portuguese assets listed, does that need to be translated into Portuguese, or does anything need to be done for it to be recognized in Portugal?
Yes, if it will have to be translated, and in many cases it will have to be apostilled. And there is still another question that if there is litigation in Portugal, it's important, and if the public authorities consider the Portuguese law applicable, it would be important that the clauses and what you dispose in this bill is according with the Portuguese law.
Okay. Um, let's see what we've got next. And okay, let's say we go with the two wills, one for the Portuguese assets, one for the foreign assets, which you mentioned. Should each will mention the foreign assets? Let's say I have a house in the US, I have one in Portugal. Should my will in Portugal say, regarding my house in the US, please refer to my US will?
I think at least refer to that you have a US will
Okay.
that will affect the US assets.
Okay. So you don't necessarily need to mention everything explicitly, all the assets in the
Yes,
other country.
yes.
Okay. Um, and if you should you assign an executor of the will in both Portugal and the other country?
If you have registered assets here,
Mm-hmm.
if your heirs don't navigate well the Portuguese bureaucracy and are not proficient in the language, I think in Portugal it makes sense to nominate an executor. In the other country, it depends on what you have and what's the concrete situation.
And should this executor of the will in Portugal, should they be a Portuguese resident?
I think it's better because otherwise you'd have to pay transportation. They're
Okay.
coming to Portugal and they might have difficulties navigating the Portuguese bureaucracy if they don't live here. But
Okay. And for someone who has a will in the US, does that need to be apostilled and translated? I think we mentioned the translated.
yes, it has to be
Okay.
enforceable here. But
Um,
there might be lots of challenges in terms of interpretation, in terms of its validity, because we are talking of systems that are completely the Portuguese system, that is a civil code system from a common law system. We are talking about very different things. So I think the challenges would be enormous if
okay.
a US will would regulate the situation of the Portuguese assets.
Okay, interesting. Now we've had some questions where people have a partner or spouse and they have children and they like their children. They want to give them the assets eventually, but they want them to go to the surviving spouse first, and then for that spouse to pass the assets down when they die. Is there a way of getting around this?
Mm, so, if you have lots of assets,
Mm-hmm.
if you're talking about one house, you might that half of the house, let's assume you can buy the house together with your partner. So half
Okay.
of the house will be from your partner. And then the other half um, could be still part of the inheritance that you can dispose. So this can be the case. But you just, according to Portuguese law, you just cannot waive your children.
Okay.
Even if you want, you cannot say the assets will go first to my wife and only then would go to our children, although in some cases it's common practice that whenever one of the spouses dies, the families don't divide immediately the houses and wait till the second
Okay.
dies, and so they divide it afterwards. And also the wife is always protected to live in the family house at least 5 years after her husband dies. So you, even if you love your wife, you just cannot waive your children from your inheritance and
Mm-hmm.
say that they will have to wait for your wife's death to become your heirs. This cannot be done like this, but there
Okay.
are ways to solve this kind of situations.
And when we're talking about children, are adult children treated the same as children under the age of 18 in this? Does it apply to any child regardless of age?
Um, in terms of the amount that you are entitled to dispose
Yes.
freely or not, no.
Okay.
But whenever they are minor, there is an intervention of the public attorney, of the public authorities to approve everything, to make sure they are truly protected. But in also in respect to the question of protecting the wife, there are always solutions that can be made. There is a something called usufruto in Portugal, which is the right to use, and you can state in a will that the property might go to your children, but your wife will remain with the right to use the house for
Okay.
as long as she lives. This could be as long as you comply with the rules about what you can dispose and not dispose.
Okay. That's very, very interesting. It sounds like there are a couple of practical solutions there.
Yes, yes, there are.
Now, does the NHR tax regime have any implications on inheritance tax?
No, we are talking
Okay.
about two completely different issues. The NHR, as we have had until now, it was a tax benefit for pensions, for pensioners, and for some activities, high value activities for income generated in Portugal, where people could benefit for a 20% flat tax rate, and also some exemption, direct exemptions in some passive sourced income. And this has nothing to do with
Okay.
inheritance or inheritance tax. There is no connections whatsoever with these two themes.
What about trusts? Are they recognized in Portugal?
Yes, they are recognized. This is not something we do in Portugal. It's not
Okay.
a common institute here, but they are recognized here.
And is there an equivalent to a disabled person's discretionary trust in Portugal?
There is not, I don't know the exact same institution in Portugal, legal institution we don't have, but there are several efficient solutions that can be created to assist financial and an incapable person after their parents' death, namely through pensions and insurance, and there are we can create solutions.
And you were one thing that you sort of mentioned there was insurance. Understand when you take out a mortgage in Portugal, you have life insurance. How does this impact everything that we're talking about today?
So it was more in the past. Now there are some exceptions, but in many cases, whenever a couple entered into a loan and had a mortgage, they were obliged to also enter into a life insurance with, normally the bank want to sell their own. And this life insurance thing, it's an important thing, because just what you pay monthly for the life insurance can have an impact on the amount that you pay monthly for a loan. But what happens normally in Portugal is, when you have this life insurance, if one of the spouses dies, normally the mortgage and the loan is immediately paid through this life insurance. This is common in Portugal.
Okay.
Not always, but it's common practice.
Now, let's say that you decide you want to change your will after you've had it made up. Do you do you do those changes yourself and have it notarized, or do you go to a lawyer?
You don't need, it's not mandatory that you go to a lawyer,
Okay.
but you have to go to a notary, and at least you should do with the notary in the notary books, and you make sure that you are absolutely explicit that this will revocate the previous one. You identify correctly the previous one, and
Okay.
you expressly state what is the content of the new will. Avoid confusions, clarify everything.
Now we've got a slightly different
And
question.
avoid do-it-yourself things,
Okay.
because you run the risk of having void clauses and things
Okay.
that are not enforceable and that are against the law would not be acceptable.
So we have one question here from someone who's resident in Portugal and someone in the US has passed away and left them a number of heirlooms, various sort of dishes and silverware. Is it possible for that person to receive those items in Portugal without paying a customs fee?
It depends on how the Portuguese authorities verify and supervise that. But you
Okay.
might run the risk to pay import fees to that. Custom
They
fees,
they
yes.
always do seem to find a way of charging import fees.
Yes. Even
Um,
when you receive now, when we have clients that receive presents or something and they have to pay taxes.
so those were the questions that came up before. There's a couple more that I can see here, so I'll just run through these with you now, Sandra. Let's see if we can find some that are hopefully not too complicated for me to understand, because this is quite a complex topic, I feel.
Yes.
If you are a tax resident of Portugal, can you avoid inheritance tax on foreign assets?
If you're a tax resident it depends. It
Okay.
depends.
I guess it depends on the other country a little bit.
Yes, it depends on the other country, it depends on the assets, it depends on many things, on the applicable law and on the
What?
country itself, because there
Mhm.
are countries that tax you based on your residency, other countries tax you based internationally based on your citizenship. So there are many, it's difficult to give an
Okay.
answer that makes any sense, just theoretically.
Okay. Suppose someone died with no heirs, so or no direct heirs, no wife and children. What would happen in that instance?
In that instance, in Portugal, it goes to the Portuguese state.
Okay. In that instance, could someone freely dispose if they didn't have direct heirs? Could they decide, I
Yes,
want to give it to
they
this
could, they
person?
could, if you don't have direct heirs
Hmm.
and mandatory heirs, you can dispose freely of your inheritance.
Okay. And a person here is asking where they could find information about Portuguese charities that they could leave the money to. I don't know if you have any recommendations on how to find those.
It depends what values and what these people cherish and value. I think it would depend on the concrete situation and what kind of people they want to have and assist.
Sure. So perhaps think about what type of charity you would leave it to in your home country and then try and find an equivalent one in Portugal. Um, let's see. And when we're talking about assets in Portugal, we've talked about things like property and a car. Are we also talking about a bank account as well? Is that considered an asset?
Yes, of
I mean,
course.
the money in the bank account. Um, and one person is asking, what if there are no physical assets and there are only investments and bank accounts? Is that treated the same as if it were something like a property?
It it's the if they are not, it depends. It depends on the amounts. If it's in many cases, if it's something relevant, it might be useful to have a will done.
Okay.
But it's
And
easier. It's easier when you don't have to face to deal with the registry.
okay. Um, and with regards to guardianship of children in the event both parents
Mhm.
die, is this something that you can specify within the will? I think you mentioned this
Yes,
briefly.
yes, but it's not automatically valid.
Okay.
It will have to be afterwards. It will have to be approved to be completely valid. But it's
And
something you can and should specify in a will.
I think this person has mentioned it in a foreign will, and they're wondering how that would be interpreted in Portugal.
Yes, I think that might be valid. You have to do the necessary steps to make these clauses enforceable here, and
Okay.
the will enforceable here.
What would you say are some of the sort of common issues that you face when you try and deal in this area, sort of mistakes that people have made, or things you would try and encourage people to avoid happening?
First of all, plan ahead. Even if it's a simple preparation, have your papers organized, have everything legal, at least draft a will, nominate someone you trust as an executor of the will, have a notion, this person should have a notion and the capability to help so that your heirs could navigate easily the Portuguese bureaucracy. Make sure your heirs get tax numbers. So a lot of small steps
Okay.
that can make things much easier.
Now, if the people who are listed in your will are not in Portugal, do the normal rules about inheritance taxes apply?
If the people, the inheritance tax, yes, it may apply or not apply. It depends on also the rules of the other country.
Okay. Um, if okay, let's say you get married to someone and that person has children, and so you have now got children through marriage. Do those now count as direct heirs?
No.
Okay. Um, this person is asking, they have a property which is in their name only. How do they add the children's names onto the property deed? And is that something that you would recommend doing now?
Can you clarify?
So this person wants to add their children to the property they own onto the deeds. And they're wondering what the procedure is for this, and is this something that you
But
recommend?
it depends on the situation.
Okay.
Sometimes I think it can always be a little bit challenge to give your assets before you die to a third person, even if it's your children, because you don't know what might happen, how they might be influenced. So it will depend on the situation.
Okay. And if they are children and you don't have a husband or wife, then it's going to go to them anyway if they're considered
Yes,
directors.
yes.
Okay. Let's see. Can I opt to have all of my assets covered by UK law? Um, so all my assets, both in Portugal and the UK, covered by UK law rather than Portuguese law.
Yes, I think it will depend. You have to have a connection with the UK jurisdiction, but this is, of course, this is possible. This is something that can be done, if especially if you're British. But it's important that you clarify, that should be clarified in a will enforceable in Portugal without any question.
Okay. Um, let's see what other ones we have left. Okay, some of these are a little complicated. And what happens in the case of families that are a little bit estranged? So you have the families that aren't in contact with someone, and someone dies in Portugal. Is there a process where someone tries to get in contact with the direct heirs?
I think in that case, if you nominate an executor, and if this executor has the identification and the contacts of the heirs, I think that would simplify things.
Okay. And just to confirm, if a married couple has no children, when one spouse dies, all goes to the surviving spouse.
Yes. If you don't have a will and if you
Hmm.
didn't dispose otherwise. No, but if you have parents, it might also be divided with the parents, with your parents. If you have survived, if your parents survive you, they
Oh, I
might
see.
also be called.
I
It
see.
depends on the situation.
Okay. And so there isn't a set amount necessarily for them, there, as in a percentage like there is with the children and the spouse.
Yes, there is.
Okay. What about the executor of the will? Does this person entitled to a set percentage of the will?
Uh, you can clarify that in the will.
Okay, but it's not
How is
automatic.
this? Yes, it's not automatic. How this role would be reimbursed and how it will be paid.
So this couple were married in the US and now have a home in Portugal that's in both their names. They have a daughter that lives in France. What do they need to do about the house in the will? Is it just a case of mentioning it? And should they explicitly mention the daughter?
I think yes, they should mention who is their daughter, who is their heir, and how they want it to be the division to be made of the house. Yes.
So even if there is sort of an automatic way that things would go to the person, does it make sense to explicitly state these in the will anyway?
Yes, and also the applicable law, what law they want to apply.
Okay. So this person should look into whether.
Because immediately, just imagine the following. You do a will. You
Hmm.
immediately declare, this is my only daughter. And this immediately simplifies things a little bit
Okay.
because there is this information in a will.
Yes, I think
And you
so.
say, and I want the Portuguese law to be applicable. Because if you don't say that,
Hmm.
the Portuguese authorities will have to interpret and to analyze and also to check what is the law of your country of nationality or state of nationality or and whether so there will be international private law questions that could be very complicated. So if you clarify and say something, and also the lawyers and notaries are very experienced, so they already know what problems they face, so they can simplify things in a will.
Okay. So I guess some of the things that you've mentioned a few times in this is first, it's better to be prepared
Yes,
than not prepared and to have a will. And then it seems like it's better to be explicit, even if the law might naturally give assets to certain people, it's better to state them. And I think there was one other thing that you mentioned a few times that I thought that was
I think it's quite important. There's many things you can choose. For instance, the applicable law.
okay.
This is something you can decide before you die, but once you die, there is no free will in that respect.
Hmm. And I think the other thing that you said was sort of to put, if you have Portuguese assets, have a Portuguese will. As a general rule, it might
Yes.
vary. And if you have
And
foreign assets,
if you have someone, a lawyer or that you trust in Portugal,
hmm.
uh, appoint this person as an executor, create tax numbers for your heirs,
Okay.
prepare ahead so it will be easier for them to navigate the Portuguese bureaucracy.
Okay. And let's see if we've got any more, because I think we're getting down to the very last few. I know once again your team have been answering a lot of questions while we've been talking. Um, let's see. What is the inheritance tax for a parent who passes away in the US but whose children are living in Portugal? How would that work?
Mhm. Can you
Yes.
clarify?
Uh,
Can you repeat the question?
I guess this maybe applies to US inheritance tax law. So I'm assuming there's assets in the US a
Mhm.
person has passed away in the US and the heirs are living in Portugal, what would happen in this
Mm.
instance?
I think probably they will pay US law, US taxes.
Okay. And you mentioned before that trusts aren't common in Portugal. Is that correct?
Yes,
But
yes.
do
They
they
are
exist?
recognized.
They're
Yes, they
recognized.
are impossible. Yes, here.
So if you had a foreign trust, it would be understood.
Yes, yes.
And how long does it take for inheritance to, for the procedure to go through and for it to be passed down to the surviving
It
heirs?
depends a lot. It can
Okay.
be super simple if everything is in order and prepared. And if you don't have registered assets, the simpler it is.
Okay. Well, Sandra, I think we've got through quite a few questions. The few that are remaining, I'm going to pass on to your team just to get in touch with people directly to answer
Yes,
them. But
yes.
we,
So, and again, I think as we did it before, perhaps we now at this moment we are a little bit full of work,
okay,
but we can perhaps the first 20 people that reach out to us, or the 30
okay,
30 that reach out to us, we will give a 15-minute explanation, because I
okay,
believe probably many people didn't see their, as a disclaimer, I'll say they won't see answers for their specific questions. So we will accept the first 30 people. They will have to write the wording Portugalist,
okay,
SG Sandra Gomes Pinto.
okay.
And of course, we will be here to help you and to clarify, to help you navigate the Portuguese bureaucracy.
Well, what I will do is I'll send an email to everyone right after this with that information, with your email address and that code, and encourage whoever's fastest to get in there and get that 15-minute call with your team.
Okay. Thank you so much. It was a pleasure to be here with you again. I hope it was clear enough what we explained. And
It was clear. I feel like I have learned so much, and I think probably everybody else has. So thank you so much, Sandra.
thank you, James. It was a pleasure. Thank you again.
Thank you.